Welcome to The Explainer. Look, today we're unpacking what is honestly one of the most fascinating, high-stakes legal thrillers in modern music history. We're talking about the multi-million-dollar lawsuit over Taylor Swift's absolute monster hit, Shake It Off. But this isn't just a story about a massive pop star, right? It's a 5-year, grueling battle over cultural ownership, intellectual property, and that incredibly fine, fuzzy line between everyday, common language and totally original, protectable expression.
Okay, let's dive straight into this. Because before we even touch the actual law here, we've got to talk about this wild internet myth you might have seen floating around. There was this huge rumor online that the entire Eras Tour was almost derailed, literally, by a rogue public domain audio sample of a train horn used in Shake It Off. People were saying this one single sound effect forced a frantic, panicked, closed-door settlement just to save the tour. Well, actually, scratch that, because if you dig into the actual federal court dockets, the real threat to Shake It Off had absolutely nothing to do with a locomotive sound. There was no train horn lawsuit, none. The actual multi-million-dollar war, it was fought entirely over lyrics. We're talking absolute linguistic warfare over a specific sequence of 2000s R&B slang from a 2001 hit by the girl group 3LW.
Section 1, the battle over everyday slang. All right, let's put on our legal insider hats for a second. In 2017, songwriters Sean Hall and Nathan Butler filed this massive federal copyright infringement claim against Swift over their 2001 track Play Is Gone Play. And the wild part? They weren't analyzing audio waveforms or drum loops. They were analyzing phrases. And this brilliantly illustrates the whole world of forensic musicology. When experts come in and completely isolate the lyrics from the melody and the harmony, you realize pretty quickly that the melodies of these two songs are totally, completely different. The entire federal lawsuit literally hinged on these specific linguistic sequences. The plaintiffs were arguing that taking the concepts of players playing and haters hating and combining them into a specific phrase was this unique, highly creative property that they legally owned. Section 2, originality versus banal language. This brings us right to the beating heart of copyright law. See, the law requires what's called a modicum of originality to actually grant you protection. You can't just copyright an idea, and generally, you can't copyright short, common phrases either. So the whole thing turned into this huge philosophical debate. Can everyday slang be legally owned just because you're the first person to stick it in a hit song? Or does it just belong to American pop culture? Well, initially, the court actually sided with the public. Back in 2018, U.S. District Judge Michael W. Fitzgerald just tossed the case out completely. He pointed out that, hey, by 2001, pop culture was already totally steeped in the whole concept of players and haters. He famously wrote that stating an actor will act in accordance with their essential nature, like a player playing or a hater hating, is not creative, it's banal. He basically ruled the lyrics were way too brief, unoriginal, and frankly uncreative to get any kind of copyright protection. So, case closed, right? Yeah, no way. A massive shockwave hit the entire music industry in 2019 when the Ninth Circuit Court of Appeals completely reversed that dismissal. They basically said, look, the bar for originality is famously low, and whether these phrases actually had that tiny modicum of creativity, that's a question of fact that needs to be decided by a jury of peers, not just one judge. So suddenly, out of nowhere, Taylor Swift is staring down a very real, extremely public, high-stakes jury trial. Section 3, the concept of thin copyright. Now, to understand how on earth we even got to a jury trial over this, we really have to look at how the law handles creative works that are basically built entirely out of everyday, common building blocks. So the absolutely crucial point here is understanding this legal concept called thin copyright. When a phrase is just barely original, like, say, taking common truisms or slang and mashing them together, it gets just barely protected. Having a thin copyright means the author doesn't own the underlying ideas themselves, right? But they might own their specific selection and arrangement of those ideas. But here's the kicker. Thin copyright literally only protects you against copying that is virtually exactly identical. Now, contrast that with the public domain. The public domain is basically all the creative materials that are completely free for anyone to use. For instance, circling back to our internet myth earlier, a natural sound like a train horn, that is public domain. Nobody can own the sound of a locomotive. And similarly, generic idioms and everyday slang, they belong to the public too. Swift's defense was exactly that. She argued these words were being thrown around in schoolyards and hip-hop culture way before 2001. Simply put, nobody owns the English language. Section 4, the 5-year legal timeline.
Okay, so now that we've got a handle on the legal battlefield, get ready to track the absolute roller coaster progression of this procedural war. Because trust me, this did not just go away quietly. Let's move through the timeline and see how this all builds up. We start in 2017 with the initial lawsuit filing. Then 2018 brings that banal dismissal by the judge. But in 2019, bam, that shocking reversal sends the whole thing right back to the lower courts. And for the next 3 years, Swift's legal team fought tooth and nail with motions for summary judgment, essentially arguing that these were just unprotectable tautocracies. Finally, in December 2022, literally just weeks before a scheduled January 2023 jury trial, and right before the massive Eras Tour was about to kick off, the lawsuit was abruptly, voluntarily dismissed with prejudice. It's highly likely the parties reached a settlement, closing the books forever without having to go through a messy public trial.
Section 5. Impact on artistic freedom. So, why does all this procedural history actually matter to you, to the modern music industry, or to the future of songwriting? Well, it matters because this case is essentially a massive, flashing warning sign about just how fragile modern music copyright has become when artists borrow from everyday culture. Here are the absolute vital takeaways if you're in the industry. First up is the merger doctrine. This is critical. It basically states that if there's only one, or maybe just a very few, ways to express an idea, the idea and the expression merge, meaning you can't copyright it, because if you did, you'd basically be handing someone a monopoly on a basic concept. Also, you've got to consider the difference in protections. Standard copyright protects robust, undeniable originality. But thin copyright battles, they rely entirely on exact sequences. What this whole saga ultimately proved is that using everyday slang now carries unbelievably high litigation risks. I mean, just think about it for a second. A super simple common phrase managed to tie up one of the biggest global superstars in federal court for half a decade. Now, what's really fascinating here is the insane balancing act we're looking at. On one side of the scale, sure, writers absolutely deserve a lock on their unique creative sequencing of words. But on the flip side, allowing people to essentially patent short, familiar expressions completely cheats the public domain. Ultimately, Swift managed to protect her masterwork, and her tour, for sure. But it took an agonizing 5 years and undoubtedly millions in legal fees just to defend the basic principle that nobody can lock up the way the public naturally speaks.
Which leaves us with a pretty profound question as we wrap up this explainer. We live in an era where pop music totally thrives on using cultural idioms and catchy internet phrases. But if we start allowing early adopters to effectively copyright our everyday slang, who truly owns the English language? It's the kind of thought that's definitely going to make you listen to your favorite radio hits just a little bit differently from now on. Thanks so much for joining me on The Explainer.